Jai Bhim, everyone, and welcome to OXAF. We are the Oxford South Asian Ambedkar Forum, and thank you for joining us. If you're joining from India, from the UK, from within Oxford, and across the world, thank you especially to Advocate Disha Wadekar for taking the time to join us today for a session on caste, campus, and the law. Just a gentle reminder that this meeting will be recorded. If we were to define OXAF in a quote, it would be this by Dr. Ambedkar, that ours is a battle not for wealth nor for power. Ours is a battle for freedom, for reclamation of human personality. We at OXAF are an anti-caste forum promoting marginalized voices and discourses from South Asia, and we also advocated for the recognition of caste as a protected characteristics in the United Kingdom's equality legislation. And as a result of our advocacy, the Oxford branch of the University and College Union, the largest trade union for Oxford University, passed a resolution in 2023 recognizing caste as a protected characteristic. This particular talk seeks to draw attention to the legal frameworks addressing caste-based discriminations in higher education institutions, as well as the University Grants Commission regulations for the promotion of equity in higher education institutions 2026. They came into effect on the 13th of January 2026 and were subsequently called into a halt. The 2026 regulations came out of Abida Salim Tadvi versus the Union of India, a case which is still pending in the Supreme Court. They also came out of efforts of countless anti-caste activists, which we recognize. OXAF is proud to present this discussion on caste, campus, and the law with Ms. Disha Wadekar. She is a constitutional lawyer and Fulbright scholar with an LLM from Columbia Law School, New York. She has close to 10 years of litigation experience before various courts in India, focusing on caste discrimination, gender justice, and minority rights. She has represented petitioners seeking legal safeguards against discrimination in higher educational institutions and challenging caste-based division of labor inside prisons. She also co-founded CEDE, an initiative, CEDE, an initiative advancing diversity and inclusion within India's legal profession and judiciary. And without further ado, let us welcome her, and the space is all yours, Disha.
Hi, am I audible?
Yes.
Yes. Hi, thank you, Sanjana, and thank you, Bheem, and thank you, Oxaf, for inviting me and having me. And I was particularly excited to speak at this forum because I was just telling Bheem that, I think I can really speak my heart out at this forum. Um, to start with, I think Sanjana has already given us a little bit of the background. And I think I want to dedicate most of this time to maybe addressing the questions. So I'll just briefly make my remarks and my presentation so that we can just move on to the questions, because I know that a lot of you might have a lot of questions. But some questions maybe I could directly address in my remarks. So I basically want to focus today's lecture on, like, the first half. I would like to focus on how the UGC 2026 regulations, equity regulations, came about. What is the background? What is the history behind this? While doing that, what I also intend to do is break and bust some myths around these regulations, or how they came about and why was the government so interested in these regulations, etc. And in the second half, I want to specifically talk about not just the 2026 UGC regulations, but the overall legal framework that exists in India around campus discrimination, and whether there is an existing framework, legal framework, and what does that framework look like does that framework even is whether it's functional, what more needs to be done to tighten the ropes, right? So yeah, starting with the UGC 2026 equity regulations, how did they come about? So I know that a lot of you might have a lot of questions, but there are some narratives and some conspiracy theories that are in circulation. One of which majorly is that, and of course, I am assuming that most of you, I would not have to address you on questions of reverse discrimination and explain and argue against this whole narrative of reverse discrimination. So I'm just going to jump right in and talk about this conspiracy theory that's going around, that why was this existing current political dispensation so interested in bringing about these regulations, right? And were there some internal deliberations, and was there a reason why these regulations were brought by the current political dispensation? Why were they so interested in this issue? So to address that, I will have to give a bit of a background about these regulations. These are not new regulations. It's not like it's for the first time that UGC has brought about these regulations. UGC already had the equity regulations since 2012. So the Promotion of Equity in Higher Educational Institutions regulations of 2012 have existed all this while. They have been there on paper. And these, of course, going by the fact that they were brought about in 2012, tells you that it's not that this government or this political dispensation has invented these regulations. They have existed, at least on paper, since 2012, right? And they were actually a culmination, like Sanjana, you rightly pointed out. They were a culmination of sustained movement and effort of anti-caste scholars and anti-caste academics and anti-caste activists, because there was something called as the Thorat Committee that was set up back in 2006. Professor Sukhdev Thorat was the UGC chairman at that point, and under his leadership, a committee was set up. And that committee was set up because around 2005-06, if you guys remember, Mandal 2 protests were happening, where all the upper caste students were out on the streets. If you are from that era, because I clearly remember I was in the 10th standard at that point and was slowly getting to learn about all this narrative and stigmatization around, around merit and reservations. And you were, all your screens and all your news channels, it was all filled with upper caste students talking about reverse discrimination and how this country is not for them. And there were these protests around OBC reservation, because that was being implemented at that point in time, right? And when these protests were happening around 2006-07 at AIMS especially, it led to a lot of harassment and discrimination, especially of scheduled caste and scheduled tribe students. And there were multiple complaints because they were being harassed by using these protests, these so-called reverse discrimination protests that were happening. They went in the name of Youth for Equality, by the way. And when these complaints came up, this Thorat committee was set up to look into instances of caste-based discrimination at AIMS, right? And then the committee did intensive work in just understanding how caste-based discrimination manifests in university spaces. It's not exactly the same way as it would probably manifest in, say, the employment sector, at a workplace, or in other public places, right? There is a specific way and manner in which, a very systemic way in which it is practiced, a very innocuous way also in which it is practiced, and also in many ways the forms of discrimination or the practices of discrimination in university spaces are normalized, right? So the committee did this intensive work of just um, understanding these forms. And the committee had done multiple interviews with students, with faculty, and they had come up with a summary of recommendations. And these identified forms of discrimination that I just talked about is what you also see in the 2012 regulations, directly reflected in the 2012 regulations. So, of course, what happened to the committee and the recommendations? Nothing. Like every committee that is set up and the recommendations that it gives, they are never implemented. It never got implemented. The committee had recommended a bunch of things. But of course, in 2012, there were these equity regulations that were passed. The definition of discrimination was broad-based, where it included caste-based discrimination, gender-based discrimination, disabilities-based discrimination, religion-based discrimination. But the forms of discrimination that I just described, that were articulated, I would say, in the Thorat Committee, those forms of discrimination also found place in the equity regulations. That was really the heart of the equity regulations in terms of definition of discrimination. And what were these forms of discrimination? So, as far as caste-based discrimination is concerned, the equity regulations of 2012 identified various manners in which this happens. So, for instance, peer-based harassment around, the idea of merit or stigmatization around merit and reservations, that was identified as a form of discrimination. Discrimination at the time of admissions, discrimination or bias at the time of evaluations, segregation based on ranking, right? Hostel segregation, mess segregation, exclusion of SC/ST students from extracurricular activities, delay in dispersal of scholarship. So, scholarship is a very important aspect of how SC/ST students are even able to sustain within the university spaces, right? And if you remember Rohit's letter, Rohit also talks about in that letter about the scholarship that was the post-matric scholarship that was granted and how there was this delay in the scholarship, and then of course says that this money should go to so and so person, right? So these are all like very systemic issues and very identifiable forms and ways in which discrimination happens, and the equity regulations record that. They take note of these forms of discrimination, and then secondly, what it does, it provides a mechanism to address these forms of discrimination. So you can look at the regulations in these two ways very broadly. What is this mechanism? It's basically a disciplinary committee, in simple terms, just for you to understand in the most simplest terms. This is like a disciplinary committee. It's an inquiry committee. It's called a grievance redressal cell. And this grievance redressal cell is supposed to take complaints of discrimination and inquire into it, and then submit a report to the head of the institution, who then acts on the committee's recommendation. And what is the punishment or the action? It is basically all civil remedies. There are no criminal liabilities. Neither can such an internal body ever have these kind of powers of punishing someone in, say, like sending someone to prison, right? For instance. So it basically, again, to make it very simple, it operates like an internal complaints committee in under the Sexual Harassment Act, right? The powers that they would have is to maybe stop someone's promotions, maybe rusticate someone in extreme cases, or in most cases, like you would have had your experience in ICC, if you've had that, it'll be just an undertaking or an apology, right? But in some ways, it did establish some accountability internally within the university space to address caste-based discrimination. Other than that, the mechanism that it again mandated was to set up it had mandated sensitization programs, so orientation, workshops that happen. So they should basically, sensitize students as well as the university community around issues of caste, issues of gender, all sorts of issues, right? So sensitization also formed one important core mandate of the 2012 regulations. And then, of course, there was bridge courses or bridge learning courses, as they call them. So these were mostly in the form of, say, if any student from the SCST community needs, or in fact, even women, it doesn't just specify SCST students, but women or persons with disabilities, anybody who needs a form of additional support in their academic learning, they can approach these bridge learning courses, whether it's English, maths, etc. And we've seen some of these. Uh, but the regulations have been there like all this while, right? So it's not like they have suddenly come out of nowhere. So that's the first thing. Secondly, we in 2019, after Dr. Payal Tadvi's death, filed a petition to enforce these 2012 regulations. Because when we filed RTIs, we realized that these UGC regulations, I'm sure, I mean, just be very honest to yourselves. How many of you had even heard of the UGC equity regulations maybe 2 years back, 1 year back? They've been there for a while. I hadn't heard them until I started doing my research in 2019, right? So most people were not aware. Like the question is that when Dr. Payal Tadvi committed or died by suicide, she was facing casteist harassment for 1 year, and she did not have a single legal redressal or recourse at the university level. And she had deliberated on many occasions to approach the police, but she did not want to approach the police, and there was no mechanism to hold the institution accountable, right? Did an equity cell or an equity committee mandated under the 2012 regulations exist at that point in time? It did not, right? Would things have been different? Maybe not, maybe yes. But should a legal redressal, a legal safeguard be there available for students facing these forms of discrimination within the university space? I think yes. So in 2019, when we started deliberating on these regulations, we realized that um, Abida ji kept saying that Payal for an entire year, Payal, her mother, her husband, had been writing to college authorities talking about the casteist harassment that she was facing from her senior peers, right? And they did not pay any heed to any of the representations. Every time they took a representation to the head of the institution, to the dean, to anybody, they would just send them back. And this is in the records. I am not talking out of nowhere. This is a part of the NCST report. Right. So Payal's mother kept saying that we did not have any redressal. We didn't know where to go. And imagine that is probably what Payal was also thinking at that point, right? So then when Abida ji suggested what can be done for a larger enforceable safeguard within the university, we looked up the regulations, we filed RTIs, and we said that let's see what is the status of implementation of these regulations. And the RTIs were quite revealing in the sense that uh, no university that responded to UGC, so there are around 1,000 universities to whom the UGC had asked that you should be implementing these regulations, and they were supposed to respond to the UGC, telling UGC if they have these mandated equity committee, what is the composition of the committee, how are they addressing the complaints, how many complaints have they received. And you won't believe that half the universities did not even care to respond to UGC about the equity regulations. So only 400 universities even replied out of the 1,000 universities that UGC wrote to. And this is the highest regulator in the country, government regulator in the country, sending these letters to universities. The rest, half of them who actually wrote to UGC saying that yes, we have these committees, were actually not talking about the equity regulations at all. They said that we have something called as the grievance cell. Now, a grievance cell is very different from and equity cell. Equity cell deals with discrimination complaints. A grievance cell is for any student and every student to approach, right? For any kind of individual harassment that they face. That is very different. So most universities just said that we have a grievance cell, and that grievance cell is what they thought is an equity cell. And the basic difference is that grievance cell deals with individualized forms of harassment, whereas an equity cell deals with structural inequalities and structural forms of discrimination, whether it's based on caste, gender, disabilities, religion, any of these, right? Um, the few universities who said that we received one complaint or two complaints in a year, even they, most universities said we have zero complaints. The ones that said we have complaints, most of them said that the person who came to us with complaint, we send that person for mental health counseling, right? So basically, if you come to us with complaints of discrimination, we'll send you for mental health. There is a problem with you. So these were the this was the status of implementation of the equity regulations. Most people that I spoke to in and around me did not even know such regulations existed. So then we got all of this data before the court. We looked at the older equity regulations and we compared it to the existing regulations also, which was the sexual harassment regulations in higher education called the Saksham regulations and the UGC ragging regulations. And we thought that if we compare the three regulations, there was another form of untouchability that was maybe being practiced against the equity regulation. Because clearly, as far as ICCs are concerned and as far as ragging committees are concerned, most universities are implementing these regulations. At least you will have an ICC in place. At least you will have a ragging committee in place. You can't find a single university or even for that matter IITs that are telling you that we can't implement UGC regulation. They have a ragging committee, right? But when it came to equity regulations, they did not feel the need to have that kind of committee. So we realized that there was one major lacuna in the equity regulation. It was mainly with respect to the enforcement mechanism. So both ragging regulation and the Saksham regulations or the ICC on sexual harassment, they had something called as a non-compliance clause, which meant that any university or college that decides that, well, we don't want to implement these regulations, they can't do that because they will have to face consequences, which means that UGC can withdraw grants, UGC can withdraw affiliations or de-recognize courses of universities if it wants to. And it has all of these powers if a certain university decides that, well, we don't want to implement all these equity regulations or these ICC regulations or whatever. So that clause did not exist in the equity regulations, which is why, we saw that all these years, these regulations have been there on paper, but nobody has really cared to implement them. Of course, some universities have something called as the SCST cell. Now, a lot of people confuse the SCST cell with the equity cell. There is a completely different mandate of the SCST cell. SCST cell is what every university, especially a public university, will have to have because SCST cells have been brought about by the UGC SCST regulations of 1998. They are only about implementing government policies, affirmative action policies, scholarships, etc., and different government notifications with respect to SCST students or staff, right? So the SCST cell has no mandate to look into complaints of discrimination. That's very different. So going back to the what we thought was a major loophole in the enforcement and implementation of the regulations was that there was no tightening of ropes. There was no sanction on the part of UGC for non-complying universities, and the non-compliance was across the board. Almost 90% universities across India decided that they have nothing to do with these equity regulations, right? So that was a major prayer. We started with a prayer of a stronger enforcement mechanism for non-compliant universities in our petition. The petition, of course, was filed by two mothers, Radhika Vemula and Abeda Tadvi. And we looked at the UGC regulations, and we thought that if there is an existing law, rather than asking for a new law, asking for new regulations, there is a need to see if we can operationalize what we already have. Um, some of the other prayers that we had were again about strengthening the mechanism, wherein we were talking about a more representative equity committee, which had a CST OBC reservation. We were talking about a more representative committee in terms of all the stakeholders. Like, you can't only have faculty members on the committee, you need to have students, you need to have civil society members. All of this representation needs to be there on these committees. Only then can they really function effectively. We were also talking about monitoring committees. So the older regulations did not have these monitoring committees, which would actually look into the effective implementation of the regulations, whether these committees are really doing meaningful work, or are they just basically telling people who come to them with these complaints that, go, you need some mental health counseling, right? So all of this was brought about in our petition, and we had some 14 prayers. I can't recollect each of them, but broadly it was about A, enforcement; B, through the non-compliance clause; B, it was about strengthening the mechanism in terms of making it more representative; and C, it was about having some form of monitoring which was independent of that equity committee, which could be a state level body or central body, which could ask them for accountability, which could seek accountability from these equity committees, because they will be appointed by the institution itself. So there needs to be a third oversight. Um, and we went with these prayers in 2019. In 2025, it took like 5 years for the court to even look into this petition. Of course, in between, the court had issued notice to the UGC. UGC had responded, etc. All of this happened. But in between, the court had also asked UGC for data on the equity committee and its status of implementation, etc. I'll not get into that. But finally, what is important for me to point out is an order issued by the court on 15 September 2025, wherein the petitioners submit a note and file a note before the court saying that UGC needs to do A, B, C, D to ensure the enforcement of legal safeguards within university spaces against discrimination. And these are our suggestions. The court writes a judicial order on 15 September, issues a judicial order, and that judicial order takes into account all the suggestions that the petitioners have made. And what are these suggestions? One is that the UGC should recognize all forms of discrimination that I just described. Second is that UGC should ensure that no segregation based on ranks happens within universities. So a lot of these universities would do rank-based allocation of hostels, which effectively meant that there would be caste-based segregation of hostels, right? Third was about scholarship dispersal, and UGC should take into account the delays in scholarship dispersal and ensure a mechanism for that. Fourth was about the grievance redressal mechanism and how that grievance redressal mechanism needs to be representative. Fifth suggestion was about personal liability on heads of the institution. So if a head of the institution decides that I don't want to take cognizance of any kind of discrimination, or it decides to be apathetic to students' concerns on discrimination, there will be personal liability that this head of the institution or staff member would face. Fifth was about protection for complainants. So when a complainant is making a complaint about discrimination, he or she usually face a lot of backlash and victimization. So preventing that, and mechanisms, there are various laws and legal frameworks that prescribe this. So we had said that that needs to be included. We had also talked about the non-compliance clause in the suggestions, and that non-compliance clause would mean that UGC could impose sanctions on non-complying universities that decide we don't want to implement the regulations. So these were some of the suggestions that the court has noted in the judicial order. The court says that UGC should pay due consideration to all these suggestions, take them into account, and strengthen their regulations and notify them as soon as possible. This is a September 2025 order. Now, pursuant to this order, the UGC on 13th January 2026 comes up with the Promotion of Equity in Higher Education Regulations 2026. And these are new regulations in that sense, but they also build on the older regulations. But more importantly, they build on the petitioner's suggestions, the 10-point suggestions that were recorded by the court. And a lot of those suggestions have been incorporated in the newer UGC regulations. One major problem with the new regulations is that they do away with the forms of caste-based discrimination in the definition of discrimination, right? Which to us was a major concern. And then we had raised this issue in court on 15th of January when this matter was listed. And we submitted to the court that these new regulations are a welcome step. They have strengthened the mechanism but diluted the definition of discrimination by eliminating the forms of discrimination from the framework. And we would want to address the court on some of the lacunas that are there in these regulations, right? And the court had agreed to this, and the court had said that you come within so much time and you please file your memo of the issues that you see with the regulations, and we will look into it. So the court does not even dispose of the matter. So for anybody who is saying or telling you or building conspiracy theories around this government wanted to bring these regulations, it was a result of a sustained movement right from 2016, the Rohit Act demand that was there to have enforceable safeguards against caste-based discrimination. The entire movement that was there, the entire movement of justice for Dr. Payal Tadvi that happened, this was an effort of two mothers who lost their children to casteist institutional harassment, right? Who felt that there is a need for these kind of safeguards. And this was that sustained effort of all these stakeholders and all of these people, because there were at least 10 reports that we had cited in our petition. And most student organizations and Ambedkarite student organizations were involved in this entire process. The NAFE committee report from JNU, the Vardhaman Mahavir College report from Safdarjung Hospital, the AIMS report of Thorat committee, the Mungekar report, the APPSC report of the open house that happened after Darshan Solanki. All of these reports and more had been a part of this petition, right? There were two scholars and academics, Professor Sukhdev Thorat and Professor N. Sukumar, who had intervened in this petition, who were asking for more changes and improvements in the regulations, right? So all of these people and all of this effort collectively has led to the 2026 regulations. Anybody who is telling you that the government wanted them, I think there is this entire history that one needs to know in terms of how they came about. And if the government wanted to really strengthen the regulations, they had the 2012 regulations, and the government was in power for the last 10 years. If they wanted to, they would have. It was a judicial order that pushed the UGC to bring these changes. So this is around the conspiracy that I basically wanted to talk about. Any questions, if you guys have, I would love to take them. And maybe while I address the questions or answer the questions, I would also talk about the framework, the legal framework that we have.
If you have any questions, please feel free to either raise your hands or drop it in the chat box and we can read it out to Disha. Yeah.
Hi, can I just ask a question? For some reason, I'm not able to find the raise my hand button and I'm having a
Yeah,
senior.
that's all right. That's all right. Please go ahead.
Yeah. Uh, Hi Disha, thank you so much for giving this presentation and a background. My name is Almas, and I'm one of the default scholars at Oxford, working on affirmative action. So I think having this background on strengthening the UGC protections for children who come into higher education spaces, it's very helpful for me to know. I think my question was more in terms of the justifications for, or the constitutional justifications. And I'm coming at it through the 29th January order because most of the questions that were carried out, I mean, you know it better than I do, was about, were red herring questions. But one of the questions that stuck was that it's not whether they are constitutionally valid. And I actually wanted to pick your brain on what basis you think it is constitutionally valid. For me, it is Article 15.4, 16.4 says special provisions, which means that it's not restricted only to reservations and it can go to scaffolding into another. But I have just been finding on just the reservations, just the entry point itself, that's where the cases end. So I just wanted to know your thoughts on constitutional justification.
Yeah, thank you, Almas, right? Um, Thank you for that question. I really wanted to anyway address this, and good that you brought this question up. Of course, I will not speak to what the court said because it's a pending litigation. But constitutionally, I think I would like to address this. So the petitioners, so after all the backlash, for anybody who doesn't have the background, Almas, you seem to have that background of the 29 January order. But for anybody who doesn't know what this order is, just a very brief explanation on that or information on that is that there was a lot of backlash and there were caste privilege, upper caste groups who were saying that, this is reverse discrimination and, we will be sent to jail and higher educational institutions are not for us anymore, etc., because of the regulations. And they were opposing the regulations and multiple petitions were filed in court, in the same Supreme Court. And these petitions basically said one thing, and they had just one demand that the regulations should be made caste neutral. And the ground on which they were saying that was they were claiming that upper caste Hindus also face caste based discrimination. They did not provide any evidence or statistics on that, but they made a lot of claims around this, and they said that we should also have protection under the regulations, right? So this was the demand. Now, constitutionally seeing Almas, of course, you already mentioned 15.4. A lot of people only seem to have knowledge about 15.5, which is about reservations in higher educational institutions. And thank you for pointing that out, that 15.4 exists. And Article 15.4 is basically talking about special provisions for scheduled castes, scheduled tribes, socially and educationally backward classes, that is SEBCs, OBCs, and women and children also, right? So it is under these provisions that most of your gender-based laws are also coming in, right? Whether it's the Domestic Violence Act, whether it's the Sexual Harassment Act, right? So any kind of special protection, special provision, special law for that matter can be made in order to protect all these communities. So that includes all of these caste marginalized communities. I would say that that is the constitutional basis, yes. But even beyond that, I think one really needs to understand that this debate of neutral discrimination laws is quite worldwide. We are also seeing the backlash that DI offices, at least I have seen in the US, that DI offices are facing that sort of backlash where white people also want to say that, well, we also want to be able to approach the DI offices for race-based discrimination, right? Or men wanting to say that we also face gender-based discrimination. And by men, I mean cis-het men, right? So basically, I would say that this discourse has existed, and international conventions and international comparative jurisprudence, if you see, they have been here and there on neutrality, but Indian Constitution has, I think, been progressive on this count, at least as far as discrimination in jurisprudence is concerned, we have not struggled like the America, right? Or Americans. We were very clear from the very start where we acknowledged structural inequalities. And we acknowledged that structural inequalities require that special provisions are made for certain historically oppressed groups whose ascriptive status doesn't change in their lifetime, in generations even, right? And that is not just 15.4, I would say, or 15.5. That is Article 17 for that matter. Article 17 really stands out to be because abolition of untouchability is what this article does prescribe. And it says that untouchability and practices of untouchability need to be abolished, but it takes a step ahead. It's not just negative, right? It's also imposing a positive duty, constitutional duty on the state to come up with a legislation, and it specifies that it should be a criminal legislation to punish the practice of untouchability, right? So, of course, you are aware that the Untouchability Offences Act and the Atrocities Act, SCST Atrocities Act 1998, has been brought under Article 17, read with Article 15.4, right? So one needs to understand that when we're comparing our constitutional jurisprudence and discrimination jurisprudence, it really stands out from the rest of the countries, even Western countries for that matter, because it very explicitly, it is embedded in our constitution. It's not a part of court jurisprudence. It is from the most originalist perspective. If you look at the constitution makers wanted to acknowledge structural inequalities and give place and give special protections to caste marginalized communities, to communities that have been structurally, whether it's women also, or other groups. It has acknowledged this sort of structural inequalities and that oppress certain groups based on their group identity and not just as an individual, right? So this has been our jurisprudence from the very beginning, and then for us to come to in 2025, 26 to talk about, oh, but our constitution is talking about formal equality and everyone is equal and everything is neutral. And that to me is quite worrying, because 75 years after the constitution, if we are moving backwards rather than moving forward, that is a very interesting constitutional crossroad we are at. And that can have the effect of undoing 75 or probably 100 years of constitutional anti-discrimination jurisprudence of India, right?
Does anyone else have anything to add or questions? Yeah. Meanwhile, Disha, Bhim and I were just discussing that despite being subjected to these targeted attacks on social media by upper caste groups, additionally, for opposing the UGC regulations, that does tell us a lot about what are the implications of opposing um, such kind of backlash, such kind of reverse backlash, in fact. And yet you continue to speak with courage and conviction, and so certainly Oxfam stands in solidarity with you, and we deeply honored that you were able to talk about and give us an entire social legal background to this. But I think in terms of what I wanted to ask essentially is that what do you think is sort of a background ideology that's going behind it? Because I was just reading through this piece on EPW that basically details this, how that the backlash against the UGC regulations reveal a persistence of insidious regressive ideologies, and how far and what are the limits of these kind of resistances. And I'm attaching it here just from a completely non-legal point of view. Yeah, if you could.
Yeah, I mean, I've read that piece. Thank you for sharing it, Sanjana. Yeah. I mean, if I may address it in this way, I mean, because I've been trying to think about what's been happening to these regulations. Honestly, when we were working on this, we did not think, we kind of thought that, this is a victory and it it would not be so difficult. Um, and suddenly, when this backlash happened, I am glad that my people from my generation are seeing all of this bear. This sort of, there is, this has really exposed people and exposed us as a society, right? And we often, I mean, I was also talking to Bhim about, how we often love to talk about the tyranny of the state, right? Whenever you are thinking from a human rights perspective, whatever, most of us really like to talk about the tyranny of state and how state this, state that. And Dr. Ambedkar, in, some, 100 years back, wrote about the tyranny of people, when he's talking about, Ranade versus Gandhi, that what is this discourse and why, Gandhi just continues to challenge or attack the state, or in those times, the colonial regime. But someone like Ranade was so much more important because Ranade was talking about the tyranny of society, right? The soil that we are, the society that we are. And Dr. Ambedkar talks about it. He says how undemocratic of a soil we are. And any kind of formal democracy that is imposed in this land will not work unless this sort of this undemocratic fascist soil and society of ours changes, right? And anybody who gives you these ideas of India's golden past or golden glory, it has never been golden. It has always been this um, a recurring debate between Buddhism and Brahmanism, the revolution and the counter revolution. And I actually see this, what is happening with the regulations now, or even the backlash with reservation policy, the backlash with any kind of policy to sort of dismantle, and I wouldn't even go so far as to say dismantle, but to reform the soil that is so undemocratic. Um, you would see that it is an iteration or reiteration of the whole revolution and counter revolution debate, right? We are still living that. And I mean, that is essentially how I would like to, I have been looking at it and I would like to see it, because this is not about the regulations anymore. I mean, anybody who thinks that this is about regulation and this is about the fight in court or whatever, I mean, is kind of being foolish. This is about that age-old debate and that age-old revolution, counter-revolution, um, discourse, right? This is whether Brahmanism survives in this soil and whether whether we will ever be able to experience or see any form of democracy in the soil. So, yeah.
I think there are two. Thank you for answering that question, Disha. I think there are two more questions. I'm going to read them out. One is from Ankita. What is the way forward now since the Supreme Court stay on the UGC equity regulations? And then the second one is from Siddhartha Arora. How can we hold the UGC accountable for not defending its guideline in court?
Siddharth, thank you for that question. So yes, UGC did not defend its regulations in court when the stay was imposed. And I think that should be, that is a telltale sign, I think. But what is the future of these regulations? And what is the future of this case? Of course, the court has framed questions. The court has stayed the operation of the regulations. And the court has framed certain questions, constitutional questions for it to answer. And one of the questions, like I said, and like, I was just telling Almaz, that is, I mean, about whether these regulations should be caste neutral. That is I think the most important question around the constitutionality of the regulations. So the court will hear us on this issue on the 19th of March. It has been listed. The matter has been listed on 19th of March, and Yeah, we hope to make our submissions, our constitutional legal submissions on this. So let's see what the future is for the regulations. But that brings me to what, other than the regulations, what is the existing legal framework? Of course, um, let's also understand what are the different um, laws that are in existence, or what are the other legal demands, such as there has been a demand for a Rohit Act and a Rohit Bill, and there are some efforts on that front as well. And let's also address all of this. So s- see, it's not like there has not been any law to address campus discrimination before the regulations, right? You have, like I said, the Atrocities Act. But the Atrocities Act brings in criminal liability, which means that there is a lot more burden on the complainant, on the victim, to actually approach the criminal justice system. And why is it a big burden? Is because it has a lot of consequences. It's about lodging an FIR, it is about fighting a court case, it is about ensuring you bring evidence, it is about following up on the case. It's a lot of things. And most importantly, in any kind of criminal litigation, whether it's atrocities or whether it's the rape law or anything, you would see that the burden is on the prosecution or the victim's side. Let me put it that way, to prove that the discrimination happened, right? So the burden is a lot more, it's really high, right? So you have to show through evidence, and that has been the biggest issue with the Atrocities Act, where the court often says that, okay, fine, you murdered this person, but tell us, why you think this was caste-based murder, right? And that is the evidence, and that is the burden that the prosecution has to discharge. In most cases, the prosecution is also compromised. The police doesn't investigate properly. The police doesn't even lodge FIRs in atrocities cases. I mean, there has been enough and well documented reports in that, right? So all in all, imagine for a 18-year-old, 19-year-old in a university space who just enters that space and who is facing this day-to-day discrimination. It's not one instance of overt form of discrimination. It's a daily discrimination that a student faces in university spaces. And that daily attrition, to have the courage to, or to expect that student, that 18-year-old, 19-year-old, to approach the criminal justice system and to pursue a criminal litigation is quite high, right? And that is the reason why criminal law and a lot of anti-discrimination legal scholars, lawyers will often tell you, at least the sensible ones will often tell you, that criminal law is not always a solution. But again, one thing that is missing, even if a student wants to approach, say, the criminal justice system and file an atrocities case, there is something that is extremely lacking in the Atrocities Act. The Atrocities Act does not define education related offenses, right? So it defines employment related offenses, it defines land related atrocities and offenses, but it does not define education related offenses. And that has been a major lacuna. And I have been telling people time and again, wherever I find this opportunity, that we need to make this demand for an amendment to the definition of Section 3 of the Atrocities Act, where education related atrocities are also included, at least the overt forms of discrimination in higher education that SCST students face. That is one aspect. That's the criminal law aspect. Um, about civil remedies, we already had the UGC guidelines where disciplinary actions could be imposed. It is a much easier, shorter process with a defined timeline, right? Less burden on the complainant to prove it, because it is only going to ensure in a civil disciplinary sort of a remedy. And therefore, why why civil remedies are essential alongside criminal remedies is also this, that campus discrimination, like Thorat committee had pointed out, and all those forms of discrimination, if you read, 80% of those forms and practices and mechanisms of discriminating against scheduled caste, scheduled tribe students are the most innocuous, systemic, and institutional forms of discrimination. Delay in disbursing scholarship money is a systemic form of discrimination. You cannot hold A, B, C person accountable for delay in disbursing scholarships, right? These are practices that have existed and normalized institutionally for years and years together. And criminal law can only punish an individual. It cannot punish a system or an institution. That is not what you can't send someone to jail. You can't send a college or an institution to jail, right? You cannot criminalize systems. You can criminalize individuals, and you can have that remedy in criminal law, which is only individualized. So that's an inherent limitation of criminal law. That is where civil remedies are important, where you get to define systemic, institutionalized forms of discrimination, and you get to hold institutions and systems accountable. Like I said, through all of these sanctions, for instance, that UGC can impose on universities, right? Tell them that your grants can be withdrawn. Tell them that your recognitions could get withdrawn. Tell them that you will not have a great NIRF ranking if you have all these systemic ways in which and manners in which you discriminate against certain students, right? So that is where the civil law really comes in. And that is the need for civil legislation. And I am aware and I have been observing that at least in some states, at least in Karnataka, there has been this demand for Rohit Act. But unfortunately, I also think from the news reports that I have read that the Rohit Act that the Karnataka government is also proposing happens to be a criminal law, which probably doesn't even define any systemic forms of discrimination because, like I said, it cannot address those forms. And it basically talks about 1.5 year of punishment. But again, it is going to be the same thing, all the issues that we have had with the Atrocities Act, we are going to have with this. Police refusing to lodge your FIRs, prosecution refusing to really, fight your case properly in court, police not investigating properly, closing your investigation. If it reaches the court, then court biases come into play, prosecutors' biases come into play. All of this, and the burden is higher and higher when it comes to atrocities cases or any kind of special law for that matter. So we are actually going in that loop of more and more law, thinking that best law is the most stringent law, even though it doesn't really function, it doesn't really deliver. We are thinking that a law with teeth is a law that has the highest form of punishment and is a criminal law. Not looking at our experience with all the past laws that have worked and that have not worked for us, right? And the feminist movement has already seen this, that their overemphasis on criminal law and their overemphasis on law with quote unquote teeth, with the highest form of punishments, has not yielded, right? And it has led to many issues. So I think it is also a time for the Ambedkarite anti-caste movement to think in terms of what kind of law are we really looking for, and what law can deliver and what law cannot deliver. There is a lot that law cannot deliver, right? So it is also understanding that. And then where do our movements, our social movements, our people's movements, what role they play? Where does the mobilization within campuses of Ambedkarite students organization like yours, where that is important, right? So it is understanding all of this.
Thank you. Thanks a lot, Disha. I think we had one last question, but I think you pretty much addressed it and summed it up about I think the Rohit Act. But thank you everyone for attending this discussion, and we are wrapping up now. And this event was made possible by the collective efforts of several current and past members of OXAF, especially Bhim, Roy, Niharika, Pratyantra, Shireen, Janvi, and many others. And in the past, we have had the opportunity to host filmmakers like Somnath Wagmare and scholars like V. Geeta for our series titled Who is My Baba Saheb Ambedkar? And Thank you for attending, and for more such anti-caste events, stay connected with us on our social media handle at OXSAF, which is OXSAAF, on Instagram, and have a good rest of the evening.